Are these in this court? This defendant?
There is one in our court and one that Kennedy did, but he was arrested in our week.
Say it again. I'm sorry.
Kennedy, or there are two arrest warrants that were not done here. One you did. That's the one that you did. Those two you did not do, but he was arrested in our week.
He was arrested in our way.
Perfect.
So is the case
It's in our court.
is in this court?
Yes, sir.
All right, court's going on the record now by Zoom. Calls number 20-1686-C, State of Texas versus Buford Lee Dixon petitioner, who is present before the court by Zoom with his attorney, Mr. D'Angelo, and Mr. Chambliss is present for the state. This is on Mr. D'Angelo's application for writ of habeas corpus challenging excessive bail. As I say, it's style calls number 20-1686-C, State versus Buford Lee Dixon. I believe that Mr. D'Angelo, I think you may already be aware of this, of course, naturally, your application for writ of habeas corpus, which I'm taking judicial notice of, alleges, sets out that on July the 14th, 2020, the defendant was arrested and charged with sexual abuse of a child under 14, continuous and sexual assault of a child. The bond status to warrant TH 20-363-F. These were set by Judge Heaton. Is now $500,000, and the bond status to warrant TH, again, Judge Heaton, 20-364-5 is $250,000. And now I would imagine you have a copy of it. Just so the record is clear, on August the 4th, which would be yesterday at 9:56 a.m., I also have before me a copy of an affidavit for charging continuous sexual abuse of a young child, first-degree felony, same defendant, Buford Dixon. The number on that one is JS 84-2020 FW2. So anyway, there's a third case where, in other words, in terms of an affidavit and bond being set for continuous sexual abuse of a child, first-degree felony. That was set by this court yesterday. So obviously the application for writ of habeas corpus challenging excessive bail, just for the record, that would go to all three. Understandably, only two are set out in the application because obviously when Mr. D'Angelo filed it, he wouldn't have known about the third one because it was just signed yesterday at 9:56. With that, for the record, the court takes judicial notice of contents of the file, which is really just Mr. D'Angelo's application for writ of habeas corpus. I have what's marked as States 1, States 2, and States 3, which I'm sure will be offered by the state. Those are probable cause affidavits and arrest warrants. Anyway, go ahead, Mr. D'Angelo, on what you've got on your application for writ of habeas corpus, which would now include the bond just set yesterday by the court on the continuous sexual abuse of a young child, first-degree felony. That bond was set by the court at $750,000 surety. So obviously that would now be part of your application for writ of habeas corpus challenging excessive bail. So your application challenges it on the first two signed by Judge Heaton and also on the one set by this court yesterday for continuous sexual abuse of a child, first-degree felony, which the court said is $750,000 surety with conditions. Go ahead, Mr. D'Angelo.
Yes, Your Honor. Having now had that third warrant brought to my attention, that brings the total bonds in this case to $1.5 million. My client is not financially able to post the bonds as they are currently set. As noted in my writ, they are excessive and they are greater than necessary to assure his appearance as to the potential charges that the state will ultimately seek to indict in this case. I have one witness that I'd like to call in support of my motion, Your Honor. It is the defendant's sister, Loretta Collins. She is available via Zoom, and she would need to be, I would imagine, put under oath so that I may briefly question her concerning my client.
As Mr. D'Angelo has said, Loretta Collins is present before the court by Zoom. Ms. Collins, just raise your right hand, ma'am. I have to swear you in as a witness. Do you solemnly swear the testimony you will give before the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Can you hear me? Can you hear me okay? I'm not seeing any response. It doesn't look like you hear me.
I don't see her having her microphone on.
Is your microphone
Let me,
on?
let me chat with her and see if I can get her to turn her mic on.
I think that's the problem, Mr. D'Angelo.
I just sent her a chat on the side, Judge, here. I think she's seeing it now. Okay, looks like her audio's connecting, Judge.
It says connecting to audio. Ma'am, can you hear me? Was this Miss Collins?
It still did not connect.
What was her name, Tabitha?
Loretta.
Loretta. All right, the screen shows Loretta Collins. So, Miss Collins, I see you on the screen, but can you hear me? I don't think she hear me. No response.
I'm texting her again, Judge, on Zoom here. Let me see if I can get her to get that activated. Okay. Okay, looks like she's got it on. Now we need to unmute.
All right, Ms. Collins, can you hear the court? This is the judge. Can you hear me?
She's muted.
Ma'am, can you turn your volume up? I'm gonna swear you in, but I can't hear you.
She still has her thing muted.
Right.
I see that it's
Correct.
Ma'am, can you hear me?
Hello? Yes,
Okay,
sir.
Now,
There we go.
Okay, Ms. Collins, I'm gonna have to swear you in. You already got your right hand up. Do you solemnly swear the testimony you'll give in the cause now on trial before the court will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, Ms. Collins, let me ask you, ma'am, to state and spell your name for the record. Would you spell it for my court report?
Loretta,
You can put your right hand down.
Loretta, Louretta, Collins, Collins.
All right, thank you, ma'am. Go ahead, Mr. D'Angelo.
Ms. Collins, how do you know Buford Dixon?
He's my baby brother.
And how long has Buford lived in the Tyler area?
For the majority of his life.
And does he have a home in Tyler?
Yes, sir.
And do you know if he owns the home outright or does he have a mortgage on that house?
He has a mortgage on it.
Do you have any idea how much equity he may have in that house?
No.
Now, you also are aware that he has these 3 pending charges, and have you heard the court lay out that there is, at this point, bonds that are in total $1.5 million? Did you hear that?
No, I didn't hear it.
Okay. Your brother has 3 pending cases. The total bonds in these cases, based upon the bond set, are $1.5 million. Have you been in touch with a bondsman?
Yes.
Who did you contact?
Mike at 3 Strike.
And did you talk with Mike at 3 Strikes about the process for posting a bond?
Yes.
So you are aware you would need to put up 10% of whatever the total bond would be that the court might consider reducing. Do you understand that?
Yes, sir.
And you'd also have to put up equity to an amount that would satisfy the bondsman. You understand that as well?
Yes, sir.
Looking at your finances and looking at your brother's finances, have you been able to put together any sort of a picture of what you could afford to post as a bond to help your brother get out of custody?
10,000.
Now that would be 10,000 out of pocket.
Yes, sir.
So if the court were to consider reducing this bond to 100,000, that means you could put up $10,000, which would be 10%.
Yes, sir.
And your brother has some property. He owns some vehicles, correct?
Yes, sir.
He's in custody. He's unable to sell those vehicles, but they are available as assets, correct?
Yes, sir.
And your brother also has some health issues. Are you aware of what your brother's going through right now in custody with respect to his health?
Yes, sir. His blood pressure been extremely high. It's
And when
been,
you say extremely high, do you have any idea how high it's been?
it's like 2 something over 1 something. And the doctor he told me that the doctor told him he's surprised he's still alive. So I talked to
Because
him
of how,
how high
so
his blood pressure is. Yes.
And Your
Okay.
Honor, I mean, to the extent that she wants to say that her brother's been diagnosed with high blood pressure, that's fine. But I'm going to object to hearsay to anything that Buford told her or Buford's doctor told her, because it's all hearsay.
All right, that objection sustained. That part of it as to hearsay.
respectfully, Judge, and
If she
respectfully,
test-
Judge, I would object respectfully, Judge, because in a bond hearing, hearsay is admissible. There is a relaxed evidentiary standard in these proceedings. We often proceed by proffer.
Okay, what's your response, Mr. Chairman?
He's correct. The evidentiary hearings are somewhat relaxed, but they're not relaxed to the point that he can just call some witness and have them testify to rank hearsay.
I'm gonna still sustain the objection to her testifying to what the medical doctor has diagnosed or prescribed. Where she's testifying to what a doctor, she says, would say.
Right. And I didn't object to everything. The fact that she's put on the record that he has blood pressure problems, I don't have an objection to that. But
I understand that.
on
The only part of the objection I'm sustaining, and I think that's what you object to, is her testifying. I understand the rules are relaxed, but her testifying to diagnosis or treatment, which she says is what the doctor says. That's the part of it I'm going to sustain.
I understand the court's ruling. Ms. Dixon, you are aware from your firsthand knowledge that your brother has a blood pressure problem, correct?
Yes.
And you are aware that currently with COVID being near epidemic in Texas, that one of the comorbidities, one of the health risks of COVID is people with high blood pressure, correct?
Correct.
Does your brother have any other health issues that might make him a higher risk if he should contract COVID while in jail?
It's the diabetic.
So he has 2 potential comorbidities, diabetes and high blood pressure. Is that correct?
Yes, sir.
And how old is your brother?
49.
And if your brother were to be released on bond and the court were to consider a bond reduction, you would be the person who would be working with 3 strikes bail bonds to get that bond posted, correct?
Correct.
And your brother would reside in Smith County if he were to be released?
Yes, sir.
And you're aware of his address?
Yes, sir.
Okay. And would you cooperate with the court in any way possible to assist in the release of Mr. Dixon and to assist in his pretrial supervision conditions?
Yes, sir.
Okay. I have nothing further at this time, Your Honor. I pass the witness.
All right, Mr. D'Angelo. Mr. Chairman, does you have any calls or questions?
I do. Ms. Collins, you'd mentioned that your brother owns a home here in Smith County, correct?
Yes, sir.
Does he own a home anywhere else?
No, sir.
Does he have anywhere else that he stays?
No, sir.
Okay, so if various other family members have told law enforcement that he frequents Louisiana, particularly Baton Rouge and New Orleans, that would not be true. Is that correct?
No, sir. That would be a tell because we're pretty close and he drives out of town. He's a truck driver.
Okay.
He comes back into town.
Where does he drive?
Where does he drive? It's different routes, different routes.
Well, I mean, most truck drivers, even long haul truck drivers, have parts of the United States that they're assigned to. So where does he drive to?
I know he mentions Latrobe a lot.
Lake Charles?
Oklahoma, huh?
Lake Charles, Louisiana?
I think that's what
Okay.
it's called. I'm not for sure.
And then somewhere in Oklahoma?
He drives back and forth to Oklahoma.
Okay. And you're his sister, right?
Yes, sir.
We're not going to go into the facts of the case, but at least two of the children that are involved in the arrest warrant affidavits are your nieces, correct?
One is,
Just one?
yes.
Which one's that?
Kiara,
Okay. You understand that they've been taken into protective custody?
yes, sir.
Okay. Are you aware of whether or not he's supposed to have contact with them?
I don't know anything about it. I just heard about it the day that it happened.
Have you been called by law enforcement?
Me? No,
Yes.
sir.
So if a detective put in her arrest warrant affidavit that she's made multiple attempts to contact you and you were instructed not to return her phone calls by your brother's attorney, that would also be a lie, correct?
Yes, I haven't spoke with anybody. I haven't spoke with anybody.
Judge, I want to also clarify for the record, and obviously I don't want to go into the details of my representation, but first time I've ever spoken to Ms. Collins was yesterday when I prepared her for this bond hearing. I've never told her not to cooperate with law enforcement. I want to make that clear.
Okay, that's clear on the record.
And that's fine, Carlo. I'm just going by what's in the affidavit. You indicated that you and is it your brother that combined y'all could maybe make a $100,000 bond?
Yes, sir.
Okay. What all kinds of assets does your brother have other than the home that may have or may not have equity?
He have a truck and a car.
Okay. Are they paid for?
Yes, I think so.
What kind of truck is it?
Oh, I don't know. It's a small bed truck. It's a work
Okay.
truck.
A newer, older?
Old truck, yes. It's an
Okay.
old truck.
All right, what about the vehicle?
Which one? The car?
The car.
I don't know if it's paid for or not, but it's there.
Okay, so you don't know what he owes against it or if he owes anything against it.
No,
Okay, what about, does he have any jewelry or anything like that?
don't know anything about that either.
Okay, what about your mother?
What about her?
She have any assets?
I doubt it. She don't fix income.
Okay. Again, we're not going to go into the facts of the case, but do you, has anyone told you what the punishment range on this type of offense is?
No, sir.
It's 25 years to life with no parole. You're not aware of that?
No, sir.
You haven't seen the arrest warrant affidavits, correct?
No, sir.
Pass the witness, Your Honor.
Anything further, Mr. D'Angelo?
Judge, I have no further questions of the witness.
All right, may Ms. Collins be excused, but she can stay on Zoom if she may want to stay on. I don't know. And if she doesn't want to stay on Zoom, well, anyway, she's excused as a witness. I'll leave it like that, whatever she wants to do. So whether or not she wants to be sitting there on camera, but she's excused as a witness.
Understood, Your Honor.
Okay, what else do you have?
Judge, I've advised my client, although he may testify in this hearing, I've advised him against testifying. I would submit by proffer that this defendant and I have discussed his assets, and I can represent to the court that based upon my discussion with him, he does not have sufficient equity in his house to make the bond that is currently set. The aggregate value of all the property that he and I discussed is not going to make anywhere near a $1.5 million bond. The defendant's wife, I should say the defendant's sister, has testified with respect to the financial ability that she has. Assuming that he were to cobble all of his assets together, at the extreme, I would suggest to the court that $200,000 would be the outer limits of what they could afford with respect to a bond, and even then they would be strapped to come out of pocket with a 10% premium. Judge, there's several factors that are set out in my motion, and I won't belabor them, but the nature of the charges, the range of punishment, those are certainly factors to be considered, but they're not the only factors. The defendant does have deep ties to this community, having lived here most of his life. The defendant is gainfully employed as a truck driver. He does own property in this jurisdiction. Yes, he does travel out of state for trucking purposes. However, the court can fashion pretrial conditions that can certainly keep a very close eye on him and limit his travel. There are several pretrial conditions that the court can fashion to make sure that he would not be a flight risk. The defendant is entitled to a reasonable bond. I would submit that a $1.5 million bond in this case is excessive and far greater than necessary to protect the community and to ensure the safety of the alleged victims. They are, as the state noted, in protective custody with other families, and he has no access to them at this time. And with respect to the bond as it is currently set, it is far in excess of what is necessary to ensure that he will appear for court proceedings.
All right, Mr. Chambers.
I wasn't going to go into the meat and potatoes of the arrest warrant affidavits. Obviously, I would ask the court. I've provided a copy to Mr. D'Angelo. I've also provided a copy to the court. I'd ask them admit those for the limited purpose of this hearing. It states B1, B2, and B3. With that being said,
all right, well, are you offering states one, obviously being states one in the sequence of the three is the probable cause affidavit arrest warrant issued yet by the court for continuous sexual abuse of a child, first degree felony. That's in JS 8/4/2020 FW2, looks like. There's another one down here, State Exhibit 2. This one was signed by Judge Heaton. Looks like on the 9th day of July. That's TH 20-363-F. Judge Heaton set the bond on that for continuous sexual abuse of a young child, first degree felony at $500,000. The third one again is with Judge Heaton, TH 20-364-F. That's a bond set at $250,000 by Judge Heaton on an affidavit charging sexual assault of a child, second degree felony. So you got to, obviously, there's a $250,000 bond for sexual assault of a child with a probable cause affidavit, $250,000 bond, surety signed, set by Judge Heaton. And then over in TH 20-363-F, there's a $500,000 bond on an affidavit filed with him, $500,000 bond for continuous sexual abuse of a child, first degree felony. That one was on 9th of July. Looks like both these are on the 9th of July, 2020. Then the third one, which was by this court, it's under JS 8/4/2020 FW2. That would just be a sequence the court was in of probable cause warrants, of course, that day, and affidavits putting numbers on. That one was by this court, set on 4th day of August in the amount of $750,000 surety. Of course, obviously, all those orders have probable cause affidavits set out. They're marked, the warrants and affidavits are marked as states 1, states 2, and states 3. So he's offered those. Do you have any objection to those for purpose, obviously for the limited purpose of a bond hearing?
No, Judge, they're judicial records, and I have no objection to their admissibility in this hearing.
All right, States Exhibit 1, States Exhibit 2, and States Exhibit 3 identified by the court. Those are all admitted into evidence for the purposes of this hearing with no objection. Go ahead.
But going into something that I think is important. I mean, obviously, Mr. D'Angelo is correct. There's other things that you look at other than just the severity of the offense. But depending upon the severity of the offense, the court is given great latitude as to how much they take that into account. It is one of the factors. Being a trucker who drives out of state, yes, there's ways to fashion his inability to leave the state. But the idea that, well, there's already been things put in place to protect the victims. One of the arrest warrant affidavits specifically talks about how that after they were taken into protective custody, this defendant contacted one of the children and said, the only way to get me out of this is for you to recant, and gave the phone number of Mr. D'Angelo to a child that he had been molesting and instructed them to call Mr. D'Angelo. That is about as egregious. It's technically another felony.
Judge, may I speak to that briefly?
Well, let him finish up.
Yes, Your Honor.
And so, again, when looking at all of the factors, it's like everybody wants the factors to only be, well, what bond can I make? And that's what is reasonable. He's looking at 2 potential life sentences with no parole and another 2 to 20. And from looking at the arrest warrant affidavits, law enforcement has been in contact with other victims who they have not presented cases on yet. So if we've got someone who's got access to leave the state, we've got someone whose family members have told law enforcement does leave the state on a regular basis, we've got someone who is contacting children in protective custody, we've got someone who's looking at potentially 2 life sentences with no parole, and then the only thing we want to talk about is, well, this is the bond they could make, and oh, there's this thing out there called COVID. Well, if you were worried about COVID, you shouldn't have been molesting children. So I think that the bonds in this particular case are utterly reasonable, and if they were higher, it wouldn't surprise me.
So I take it from your argument, the state's position is, I think it's clear on the record, that the state's position is all 3 bonds should remain as they are, just so it's clear on the record. That's what you're saying, is that correct?
That's correct, Your Honor. We think that the totality of the circumstances and the evidence before the court justifies denying the petitioner's request for relief outright.
Anything else, Mr. Chambers?
Yes, Judge, I want to speak to the
Let me see if you,
communication.
I'm getting ready to go back to you, Mr. D'Angelo. Mr. Chambers, do you have anything else?
I don't, Your Honor.
All right, go ahead, Mr. D'Angelo.
Yes, Judge, respectfully, I want to address that allegation, and I am familiar with what happened. To be clear, the child was placed in a protective custody at the time. It is my understanding that the child had obtained a phone somehow while in that custody and made an outside call. It is my understanding that the outside call was to my client. My client did not have access to the child given the circumstances and the custody she was under. She had an ad litem attorney, Mr. Carter, and she was in CPS protective custody. It is my understanding that the child reached out and the child wanted to recant. Yes, it is correct that the child was given my phone number at my office and called my office. My assistant did speak with a person who identified themselves as the child, and the affidavit correctly sets forth that that call was put on hold. When my assistant returned to the call was hung up. I want to make it clear for the record, Judge, that I don't see anything in this chain of events that suggests that my client orchestrated or attempted to tamper with this witness. The witness and the child victim contacted my client from a number that, for all intents and purposes, he would not have recognized as being her number. He did the right thing, as is noted in the affidavit, and brought all of that to my attention. If a victim wants to recant, in his mind, he made the right move to say, you need to talk to my lawyer. I then contacted the ad litem attorney, Mr. Carter, and I contacted Detective Brock, and I made them aware of the communication. And if there was going to be any sort of a change in this child's assertions and allegations, that would be done through the proper channels, through the ad litem and through the detective. So while I understand the state's position and their frustration with respect to the allegations in this case, I want the facts to be clear that I don't see that my client initiated any attempt to tamper with this child. I don't believe that he had the ability to reach out to the child. Yes, she did reach out to him, and yes, he did advise her to contact his counsel. And I just want to state that for the record, Judge.
All right, Mr. D'Angelo, it's on the record. All right, anything else? You're the movement, Mr. D'Angelo. Anything else? I know that apparently you don't have any other witnesses, correct?
No, sir, Your Honor. I would rest. I think I've already made my argument, Judge.
You have. I just want to be sure you'd rest. You've rested and made your argument. The court offered the animal mistakes exhibit 1, 2, and 3. Those are the probable cause affidavits, the arrest warrants, which reflect the bonds in all 3 cases. I believe I have already admitted in mistakes 1, 2, and 3 without objection, or admitted into evidence. I believe it was without objection. They're admitted in states 1, 2, and 3. I don't know what, I believe that would be basically then your closing argument, Mr. D'Angelo, you just made, since Mr. Chambliss has made his argument. Do you have anything else, Mr. D'Angelo?
I don't.
No, Your Honor.
Okay. Well, Mr. D'Angelo does not have anything else. Mr. Chambliss does not have anything else. So it's submitted to the court. The court will need to go back and review the first 2 probable cause affidavits, along with the one in this case, March states 1. Court will go and review 2 and 3. The probable cause affidavits, which I've admitted in under states 1, 2, and 3. And then consider what arguments are of counsel. Then I'll get you out an order on your application for writ of habeas corpus challenging excessive bail in all 3 cause numbers, Mr. D'Angelo, just as soon as I can. Anything
Thank
else?
you. No, Your Honor. Thank you.
All right, we're in recess. Thank y'all. This right here. I'm gonna hang on to this so I can take it into my office to have